Good afternoon, everyone. Thank you so much for attending. My name is Natalie Garnica, and I'm here with my colleague Alero Egbe. We are staff attorneys in the Child, Youth, and Family Advocacy Project of Public Counsel. The focus of our practice is the intersection of family, probate, and dependency court and helping families stay together or reunify after periods of separation. Many of our clients are young people who've experienced foster care and they are building relationships with their own children, ideally outside of the foster care system. And as we noted, we're going to be monitoring the Q&A and then, but if you want to introduce yourselves in the chat, feel free to. And we'll go ahead and get started. I'll pass it over to Alero.
Hi, everybody. My name is Alara Edba. I'm a staff attorney, as Natalie said, I'm a staff attorney with the T team. And we're so glad to have you all here, and we'll get started. So today we're going to cover a couple of things. So we're going to walk you guys through probate guardianships as an overview, and as part of that, we'll talk about alternatives to guardianship, objecting to a guardianship, terminating a guardianship, and then visitation within the context of guardianship. So, a probate guardianship is a legal process that transfers legal custody from a parent to a non-parent so that the non-parent can make almost all of the same decisions that a parent can. In California, non-parents can petition the probate court for custody of a minor child if the child's parents are unable or unwilling to care for the child. If that guardianship is granted, then the parent's custodial rights are suspended but not terminated during the guardianship. Probate guardianships are really are a good option to care for children in situations where a parent has passed away, is currently incarcerated, or can't take care of their child for another reason. But this status can be abused, and it can result in unnecessary parent-child separations. So there's a few types of probate guardianship. AB4, there's a traditional guardianship where parents' rights are suspended and the guardian steps into that parental role for a child. But AB 495, that was passed in 2025, has expanded what guardianship looks like, and now gives parents and potential guardians the option of joint guardianship. So in that situation, the parent and the caregiver share legal decision-making power, but the parent's rights are not terminated, or sorry, are not suspended. All guardianship, the parent's rights are not terminated. In a joint guardianship, the parent's rights are also not suspended. You might hear about temporary guardianship, and in California, there is no true temporary guardianship. So probate and dependency are not the same. So dependency, also known as foster care, the foster care system, happens when a government agency, so CPS, DCFS, investigates and files a petition in California, files a petition under WIC 300. And the goal of a dependency case is reunification of parent and child, and you progress towards that with services and timelines. Um, Parents and children are appointed counsel as they go through this unification process. So the WIC 300 petition states that the parent has abused or neglected their child, and this can sometimes come with removal. Um, Sorry. And like I said, there's a plan of service, there are specific timelines by which all parties must act. It's much more of a formalized process with guardrails, for instance, like appointed counsel. Versus probate guardianship, there's no government agency investigating a parent. That probate guardianship, a private citizen is petitioning, saying that the parent cannot care for their child. The goal of a probate guardianship is not inherently parental unification. It's a custody order in the child's best interest. So there's no reunification services that are offered. Um, and sorry. There's no appointed counsel like there is in a dependency case. A parent can get their own counsel. The parent has to hire their own counsel. Um, a minor's counsel can be appointed, but this is not automatic. And because of that, indigent parents often will lose in a probate guardianship case, and they lose the right to care for their children because they don't have access to counsel, and they often aren't in a position to put together a persuasive case to show that it's actually in their child's best interest to remain in parental custody. Um, so there's a risk of hidden foster care with guardianship cases. Um, Sometimes CPS pressures parents into agreeing to a temporary guardianship rather than risking a case in dependency court. And For some parents who are unlikely to reunify in dependency court, this may make sense as a good option. But for parents who do wish to keep custody or who do want to reunify, it may not. And hidden foster care specifically happens when a child welfare agency, so that can be state or tribal or county, really pressures parents into giving care and responsibility of their child to others, and those others are usually relative caregivers. This is considered hidden foster care because there's no dependency court case that's opened. Agencies will often suggest it's better for the child and family because the child isn't entering the foster care system officially, and the child is gonna stay with people who they have a pre-existing relationship with. Um, and that can very well be true and it is often true, right, that if a parent is unable to take care of their child, then being cared for by someone that they know and trust is very healthy and supportive for their child. However, there are major concerns with hidden foster care. For one, because a dependency case is not opened, these separations aren't being tracked. So we don't have numbers on how many families are being separated outside of the court system. And because we don't have those numbers, we can't properly assess and improve avenues for child welfare. And the second concern is the lack of due process. So in dependency cases, like I mentioned earlier, the goal is reunification. Parents are provided attorneys, and parents are given a list of services that they need to complete in order to regain custody. So in order for a dependency case to happen, first the agency has to file a petition under WIC 300, which means they must clearly state their concerns about why they believe that a child is being abused or neglected. The judge will then identify clear goals with deadlines for the services that the parent needs to complete, and the agency is supposed to support those parents in meeting those goals and completing their services. And caregivers, including the relative caregivers, are given resources, including financial support from the date of placement. But in probate court, like I mentioned, the goal is not reunification. So parents are not provided with attorneys, and courts are actually expressly prohibited from ordering reunification services because the goal is not for the parent to regain custody. The goal is not reunification. And also, caregivers are not entitled to financial support or resources. So hidden foster care often hurts parents because they aren't guaranteed the right to legal support, and because they don't have the right to legal support, it's really hard for them to make a informed decision, and it's hard for them to assert their right to challenge the need for separation in court or the right to pathways for reunification. Um, Hidden foster care often hurts relative caregivers because they don't have access to the kind of supportive services that the state agencies would provide in formal foster care cases. And hidden foster care often hurts children who may be moved to an unsafe house and may not understand what's happening to them. Next. Okay,
So,
I'll turn it over to Natalie.
yeah, so I'm going to talk briefly about alternatives to probate guardianship. And so, we're going to go ahead and talk about informal caregiving. So, It is not necessary in California for someone to have custody of a child. If a parent isn't available, the child can live informally with someone else for extended periods of time if the parent agrees, and that person that the child's living with is able to make basic decisions about the child's care. So, families often will seek to establish a legal guardianship for many reasons, including some where the guardianship may not be necessary. These situations include where a caregiver is caring for the child temporarily and a parent's plan is to reunite with the child. Sometimes these situations happen because a parent is facing homelessness, domestic violence, or has been incarcerated or deported. And so, one tool that folks who are caregivers can use that is not, that it doesn't rise to the level of a probate guardianship is a caregiver's authorization affidavit. And so, a caregiver's authorization affidavit is a legal tool created by the Family Code that allows most relative caregivers to make some educational decisions for a child, make the same medical decisions for a child as guardians would be able to, and they might be able and they can apply for CalWORKs. It's not required to have the caregiver's authorization affidavit to apply for CalWORKs, but it can be helpful. Um, and a CAA is great because non-relatives can also use it. You know, family support come and families come in all different makeups. And so a child might be living with a godparent, for example, or a cousin of their parent. And so they may not meet the expanded definition of who a relative is under the family code, but a non-relative could still use this form to enroll a child in school and consent to school-related medical care. And the one of the great things about a CA is it is very limited. It prioritizes a child's continuity for a child. So, for example, if a parent is unable and perhaps let's use the example of deportation. If a parent is deported just before the school year starts and the child is living with their grandmother can just enroll them in the same elementary school that they've been going to using the caregiver's affidavit without having to take custody away from the parent. However, the CA does not give someone custody or guardianship. You can't use it to enroll a child in a daycare or a preschool, or to just check a child out of school. You can't use it to obtain vital documents like birth certificates or obtain regional center services or apply for SSI benefits. So it really is a tool for limited circumstances, and it can be really helpful for families where the plan is to reunify the child with the parents. And lastly, I just want to put a pin in the regional center services. It's actually not clear in the law whether the CACAA gives a person the ability to make decisions. So that's a little unclear. But to address some of the limitations, so a parent who is thinking, for example, or concerned that they might be that they might be facing deportation or that they might be facing incarceration, they can use a caregiver's authorization affidavit and instruct the caregiver to use one, and then also sign specific authorizations under Family Code section 6910 for specific medical decision making, and then also under Government Code section 7570.5 for educational decision making authority for a child with special needs. Um, so caregivers authorization affidavits, there isn't one specific form, but we have a form on our website that we've created that conforms with the Family Code section. Sometimes hospitals or schools will have their own version of the form. Some important things to note is it does not need to be notarized by anyone. It does not need to be signed by the parent. It should be signed by the informal caregiver who is stating under penalty of perjury that everything in the form is correct and true. It does not need to be stamped by a court or other authority. Again, some of the beauty of the CAA is that it can be used sort of at a moment's notice. If the parent can't be easily found, then that's okay. The person who's caring for the child can use this to make sure that the child gets the medical care that they need or is able to enroll in school. And so I also want to, so in informal caregiving situations, um, there is still a lot of flexibility for parents. And before a legal guardianship is granted, and while, for example, a child is living with a grandparent and enrolled in school through a caregiver's affidavit, the parent retains their right to care, custody, and control of their child. And so, if the relationship between the caregiver and the parent starts to fracture, or the caregiver stops engaging with the parent, then a parent has options available to them. So, for example, the parent can request that the caregiver immediately return their child to them, absent any other court orders. Um, the parent can simply go to the school and pick up their child. They can, take the child back into their care with, hopefully without an issue. Once a request for temporary guardianship is made and granted, so once there's an order on guardianship, the parent might have to wait for many months to reestablish any contact with their child if the relationship between the caregiver and parent has fractured. So when a parent is ready to pick up their child and the child is still in an informal caregiving situation, parents should politely, calmly, firmly inform the caregiver that they're going to pick up their child, document all of their efforts to pick up the child from the caregiver. So that means calling and texting, sending messages, and physically going to the house to try to pick up the child, and then seriously consider involving law enforcement if the caregiver will not release the child to the parent. We have had cases, and I've had recent cases where there was a dispute between mom and paternal grandparents, and mom was able to ultimately pick up her child from school because grandparents were not giving her the child and not being responsive to her, and not they weren't there when she enlisted the help of the police. She was able to pick up her child from school because she had her certified copy of his birth certificate and the court orders showing that she had sole legal and physical custody of her child, take him back into her care. And ultimately, the grandparents were not able to obtain a temporary guardianship over him because he was already in his mother's care. So it's really important that the parent is as forceful as is prudent in following through with their request, that they're ready to that they're ready to care for their child again, and then pick up the child, because often once it gets to this point, that's when the caregiver would be filing for guardianship. And once a temporary guardianship has been granted, it can be very, very difficult for a parent to reestablish contact. So I'll turn it back over to Alero to go over the guardianship process.
Okay, here we go. Um, the life of a probate guardianship case, um, the petition is filed by the would-be guardian. There's a temporary hearing or hearing on whether to grant a temporary guardianship. There's a probate investigation. There's an appointment hearing, and then there is a trial. Um, so after filing the petition for legal guardianship and a few associated forms, there's a hearing before a probate judge in about 12 weeks. That would be the appointment hearing. The temporary hearing is usually about 10 to 12 days after filing. And the temporary hearing is where most people are going to get their initial orders. There's usually not orders that are granted between the filing of the petition and the temporary hearing. The appointment hearing is usually that 2 to 3 months, that 12 weeks, and or sorry, 2 to 3 months from the temporary hearing, which can be um, even longer depending on, which is obviously even longer after the petition is filed. Um, so if there is a temporary guardianship, if it's sorry, before this temporary hearing, the petitioner has to um, get before all hearings, the petitioner has to give notice. And again, between this appointment hearing is when this probate investigation happens. Like Natalie mentioned, it is really, really important for parents to get, if they can, to get the child back in their care before the temporary hearing or at the temporary hearing. At the temporary hearings are very brief. And so there's usually only a couple sentences. The judge will only consider the few sentences of what's on the petition and the testimony of the parties, and then they'll make a decision in about 5 minutes or so. So if, for instance, the child is already with the guardian, the judge is far more likely to keep the status quo and allow the temporary guardianship to be granted, as opposed to if the child has already been returned to the parents, the judge is more likely to deny the temporary guardianship and again keep that status quo. If visits are ordered at the temporary hearing between the parent and the child, those visit orders are usually vague and unenforceable, especially if a parent is tackling the temporary hearing, the hearing on temporary guardianship without counsel. And so it's really important for parents and counsel to push the court to make specific orders. So orders saying the date, the time, the exchange location, the same way that you would in family court. And that's really important to show a clear record, right? That the parent showed up for the visits they're supposed to, that the guardian did or did not allow those visits to happen, and also for enforcement, that a parent or guardian is able to get, if necessary, law enforcement support to enforce their rights to visit. In many cases, those visits will start off as supervised, either by a professional monitor or the proposed guardian. And in those cases, a professional monitor can cost like $100 an hour, even more. And so for a lot of parents, particularly indigent parents who, again, will not don't have access, often don't have access to legal counsel, $100 an hour, 100+ dollars an hour is just untenable. And so with that, if it's a professional monitor, that may functionally mean no visits. So it's really important for parents to be able to suggest um, a non-professional monitor, and even more, not the guardian as the monitor. As you can imagine, there can be really significant tension between the proposed guardian and the parent. So having the proposed guardian or temporary guardian supervising the visits can really make them uncomfortable. Um, and you can, of course, at any point, either party can request an ex parte order, but um, whoever is requesting the ex parte has to show irreparable harm to the child. It's a high standard, and lack of parental contact is not deemed to be irreparable harm that would justify, for instance, an ex parte guardianship being granted between the petition and the temporary hearing. Um, so the petition is what starts the case. A parent can file the petition, a proposed guardian can file the petition, or a minor child that is over 12 can file this petition. And to To succeed, the petitioner has to show that the guardianship is necessary or convenient, um, and in the child's best interest. So if a parent objects, then the petitioner has to demonstrate that parental custody would be detrimental to the best interest of the child. And it's important to note that detriment can be shown by length of time with caregiver. And many caregivers argue that they are de facto parents. Um, and before a petition can be granted, the petitioner has to give notice, or notice can be waived. And personal service um, is required at least 15 days prior to the court hearing, unless the court orders that providing notice would be contrary to the interest of justice, or the individual cannot, with reasonable diligence, be given notice. And in our practice, we've seen many times, I'll probably note it on another slide, but we've seen many times that potential guardian um, who has filed a petition will say that they could not find the parent to give them notice of the temporary hearing. And that's often not true, right? Like the petitioners will say this while they have email contact, have phone contact with the parent. Um, so it's not a strict, the court will sorry. There's not a thorough investigation as to whether proper notice was given. Um, the petition for temporary guardianship has to be filed within a petition for appointment of guardian, or after a full petition has been filed. That temporary guardianship hearing again is held pretty shortly after filing the petition. Um, the petitioner must provide notice. Um, as per probate code 2250, at least 5 days prior to the hearing, unless they can waive notice with a good cause exception. The petitioner has to show that there is immediate and compelling need for the appointment of the temporary guardian. Um, so in California, again, you cannot request a standalone temporary guardianship. A temporary guardianship can only be requested if the caregiver has also requested a permanent guardianship. Um, and so it's a common myth that there is such a thing as a standalone temporary guardianship. And parents and would-be guardians are often encouraged to seek this temporary guardianship that would end at a specific date, or when the parent has remedied an issue. And again, that's just not something that is possible under California law. It's easier to think of a temporary guardianship as more of an emergency guardianship, and that something that is granted when a caregiver needs legal guardianship immediately, and they can't wait until that hearing on the permanent guardianship that might be 2 to 3 months out from when the petition is filed. So that means that the temporary guardianship is made on an emergency basis. So that would mean that the interest in the minor has to be protected immediately, and they can't wait until that permanent guardianship is effective. Um, and like I said, it is really common, despite this requirement, to give notice for a potential guardian to state that they don't know how to contact the child's parent. And if the court believes that, then again, that would fall under the good cause exception of notice, and is what makes it really important for parents, if they actually do have notice of the hearing, to appear and state their objection. And once a temporary guardianship is granted, it's going to be in effect pending the final determination of a regular petition for guardianship, unless it's specifically terminated by the court um, between when the temporary guardianship is granted and the hearing on the regular guardianship petition. Next, please. Um, so after filing of the petition, there will be a probate investigation. And in that time, the court social workers will reach out to the guardian. They'll interview the guardian and they'll write a report, or the potential the temporary guardian and the potential permanent guardian, and they will write a report based on what that guardian says. The DCFS has a probate unit, and they will do the investigation if the caregiver, potential guardian, is not a relative. It's important to note that whoever is investigating, they don't do home visits, and they might only do a virtual appointment. They usually do not contact parents. They usually do not interview the child without the caregiver presence, and parents do not get online access to the report. Um, and only minors counsel and the court have online access. So the guardian, the parents, the attorneys have to go in person to request a copy and show an ID in LA County. Um, and the goal of an probate investigation is to figure out if the proposed guardian is suitable. So if you are a parent involved in and trying to object to the guardianship, it's really important for parents to be involved in the investigation. So that might mean that usually will mean reaching out to the probate investigator and requesting to be interviewed. Their final report is going to include conclusion, an assessment of whether or not a guardianship is needed. It's going to include concerns and recommendations that might include steps like referrals to social services, and it will include recommendations about visitation between parent and child. Oops.
I was on mute. Sorry, everyone. I do want to just note in the chat that we had some comment about the probate investigation process, at least in San Diego County. It sounds kind of similar to Los Angeles in that there is the the investigator is not necessarily doing a lot to move the investigation along. That it's in San Diego County, the petitioner is tasked with providing family court services with the paperwork, and then they're told who to contact and where to contact. So you can see where maybe things would go wrong if the petitioner doesn't provide that accurate information. Um, and yeah, it's likewise in Los Angeles County, it's incredibly confusing to people, and a lot of people miss the conference all over the place. And I agree. I think that we could, that the probate investigation process could be really improved. And yes, I see Olita left a comment. We can share out our link to our caregiver affidavit form. And I meant to mention at the top that we actually have a manual on representing bio parents in probate guardianships, and we'll be distributing that after the presentation as well. So I'm going to go over objecting to a guardianship, and I want to make sure we still have time for questions too. So I'll jump into this. So a parent can object to the temporary guardianship if they are able to find out about the guardianship prior to the temporary being issued. They can appear in person at the hearing, orally state their objection. If possible, they can file a written objection in advance of the hearing on the temporary, but due to that quick timeline, it may not be possible to get that written objection in. So if a temporary guardianship was issued without notice, parents can also consider filing an ex parte request to terminate the temporary guardianship for lack of notice. It's important, I think, to do this so that the court can be made aware of especially if there are facts to show that the guardian was actually in contact with the parent, knew where parent was. If parent and child have had really frequent contact with each other prior to the granting of the temporary guardianship, it's important to get that all before the court. We would say not to get your hopes up about the temporary guardianship actually being terminated for lack of notice. At hearings on temporary guardianships, parents should be prepared to explain why the guardianship isn't necessary. why it's in the child's best interest to remain in or return to their care, and the parent should be prepared to address any allegations that were made against the parent by the caregiver in the petition. The strongest evidence, of course, would be if the child is already back in the parent's care, and the parent should explain that to the court. If there are family court orders that are recent, that could also be important evidence that would also be important to tell the probate court about. And if the parent has been attempting to take their child back but has been met with resistance by the caregiver, then those efforts should be explained as well. It's very important to set client expectations at this stage. If the temporary guardianship has already been granted, it is, in our experience, extremely unlikely that the parent is going to be able to get anything other than visitation pending trial on the permanent guardianship. And it could be a very long time before the parent gets regular overnight visits with their child. Significant chunks of time with their child is very important to set client expectations out for the long-term separation from their child there, and to remind them that while this temporary guardianship is in place, like they do not have their parental rights are suspended, and they are going to have to be working with the guardian. So, objecting to a guardianship, if we're past the temporary stage and now we are just waiting for the hearing on the permanent guardianship, it's important to file a written objection as soon as possible. There's GC 215. It's a new wish optional judicial council form, as an option to attach a declaration to it. We always attach the strongest declaration we can with points and authorities, explaining the parent's side of the story. It can be really key to show, especially for younger children, the amount of time that the child was being cared for solely by the parent and living with the parent. And then additionally, it's important just appearing at the hearing and orally voicing an objection to the guardianship is likely not enough. So this written objection is really important, and and you have to be ready to argue at the hearing. You know, California Family Code Section 3041D is, why is the guardianship necessary and what is the detriment in returning the child to their parents' custody? De facto parent status can become key, and it is often the heart of these protracted contested probate guardianship issues. Essentially, once the guardian has cared for the child for enough time to show that they have been stepping into the role of the parent by meeting the child's emotional and psychological needs, then the burden shifts, and there's a shifting burden of proof, and essentially the parent then loses the. It's very easy for the presumption that parental custody is the preference in California, for that presumption and that preference to be defeated by a guardian who has de facto parent status. And again, because in probate guardianship, the controlling, it is about the best interest of the child. The goal is not reunification. And so we see cases frequently where a child is bonded with their parent, and they also have a bond with their guardian. And because the guardian has been able to demonstrate de facto parent status, the court finds that it's in the best interest of the child to remain with the guardian. So in representing parents in contested probate guardianship proceedings, you have to be prepared to go to trial. They generally cannot share custody permanently, and it can be incredibly hard to settle guardianship matters. Because most litigants in probate guardianships are unrepresented, trials are rare, but it might be the only way for a parent to regain physical custody of their child. And so if you're preparing a client to go to trial, there's going to be, you're going to be preparing a trial brief outlining the law and all of your legal and factual arguments. You'll be including a witness list of all the witnesses you intend to call, um, and an exhibit list as well with exhibits, um, that you need to make sure that the other side and that minors counsel is aware of. And trials in Los Angeles County are generally scheduled at 1:30 p.m. and span across several afternoons and sometimes over several weeks. So you could have one afternoon in January, two afternoons in February, and finish in March. At the conclusion of the trial, you'll have the opportunity to make a closing statement. And we think it's generally a good idea to ask for a specific statement of decision. Again, parents are the underdogs in cases like this, and so it's important to see what the court's reasoning was. And so I'll turn it back over to Alero to talk about terminating a guardianship.
So after a guardianship has been ordered, has been granted, the parent should reestablish contact with their child. So that means asking the guardians for visits and visiting consistently under any conditions that the guardian allows, as much as possible. And if the guardian is allowing no contact, that means filing a request for visits with the court. And again, expecting to begin with supervised visits. If you're filing to terminate the guardianship, you can file as many times as you like, but be careful with that. Um, and if you file to terminate, you want to ask for a trial. Um, and in your request to terminate, a parent should address any and all issues that led to the guardianship, include and address issues that might be brought up by the guardian. So that means, really addressing and often proving stable housing, stable employment, the stable mental health issues, substance abuse, again, substance abuse being no longer an issue. And there's no reunification services that are allowed in probate or family court, unlike, again, dependency court, although sometimes judges get a little bit confused about that. Um, After reestablishing contact and addressing any concerns, that petition to terminate is going to be GC 255. And again, the standard for guardianship, both granting and terminating, is best interest of the child. The petitioner has the burden. The petitioner is asking the parent has the burden of proving that guardianship termination is in the child's best interest. Um, We've seen that former guardians are granted visits even if the guardianship is dissolved. And again, it's important not to file a meritless petition. Again, you can file as many times as you like, but it's really important to, if you're going to file for a termination, do it when, again, you have the best possible fact pattern, the housing, the employment, the stable mental health issues, the substance abuse. And I'll pass it. Oh, sorry. And then just briefly, there's a potential for adoption after there's been the guardianship has been in effect for over 2 years. So it's important again for the parent to steadily but quickly as possible address the concerns so they can file a request for termination within those 2 years and hopefully have it be successful. And I'll turn it over to Natalie.
So I'm going to talk about visitation. And in our cases, we have found that visitation and increasing visitation is one of the most powerful tools that a parent has to show that the guardianship is not necessary or that and that their children being in their care, it's not detrimental to the children to show bond between parent and child. And so it's important to note that absent any court orders, visitation is completely at a guardian's discretion. This can be very difficult for parents to be in a state where the guardianship is in place, but there are not visit orders. And so And, at that stage before a visit order is in place, it's important for the parent to politely and regularly ask for visits and document their responses and to visit whenever is allowed. It can be hard for parents who are used to having the custody and care and control of their child to feel like they are like they to really feel they don't have that control anymore and they don't get to choose when or where the visits take place, but it can be at the end of the day, it's important for them to demonstrate and prove their devotion to their child by visiting whenever allowed. In figuring out the strategy for the type and schedule of visits to request in a petition, um, you want to consider the greatest frequency of visitation that's realistic, considering the client's schedule, what the client knows about the child and the guardian schedule. You don't want to request something that then ends up making the parent look out of touch, and like they don't know their child. So, and it's also important, there isn't a specific court form for this. It is just on pleading paper. And in our experience, we ask for visitation. We lay out the facts that support the visitation petition. We have a sample in our manual that we'll be distributing. It's really important for clients to not overcommit to a schedule that they actually can't do. Just like for folks who also practice in family court, canceled visits where the parent is late are worse than a visit schedule that is less frequent, but that the client actually can meet every single time. So it's important to also check in with client between visits to see how they're going, because in between, one strategy that we have found to be quite helpful is if we can get visits ordered at the beginning, even at the temporary hearing, and then setting a return date, and then trying to increase visits at each return date so that by the time we do get to trial, the parent has, overnight visits on a very regular basis with their child. It becomes more difficult for the guardian to show that this is really a necessary guardianship if parent already has their child, for, you know, first, third, and fifth weekend, Friday to Monday. Um, it's really important, though, for the parent to be aware of how long it can take to get to that place and that they might have to start out with supervised visits, that they need to always show patience and be calm and polite in their interactions with the guardian, and to make sure that they, again, show that commitment and that they do not cancel visits or miss visits. Um, and the last thing is that, we have visitation orders are orders of the court, and even though and that guardians are expected, and it is a duty of a guardian to follow court orders. And so in cases where a guardian starts canceling visits, it's important for parent to document and to still show up and not just get into back and forth with the guardian about whether or not the visit is going to happen. It should just be parent shows up and that is documented, ideally by like a brief text message, or sometimes guardians and parents are ordered to use talking parents, but they should have some evidence to show how visits are going. Um, and so I think that concludes the material that we were going to go through today. We have just about 10 minutes for questions, and we are so thankful for everyone that is attending and for the comments we've received so far. And since I want to make sure everyone gets full MCLE credit, I will just briefly chat about a couple of things. So I have had a situation, that last example that I was talking about with a petition for visitation, and then how important visit orders are. We recently had the court terminate a guardianship for a guardian's failure to comply with court ordered visits, and because the guardian refused to engage refused to make the child available for visits, and because our client diligently showed up for her child and documented her efforts for like 8 weeks. Ultimately, the court terminated the guardianship because of the guardian's refusal to obey court orders. So I see a question from Rachel. Um, where there is joint guardianship, what happens if parent and guardian disagree on a decision? I think that is a great question. I see Sharon is getting ready to type an answer, but joint guardianship is fairly new in California, or at least the new expansion of it. It has been in California, joint guardianship has been available to terminally ill parents. So if a parent has, I believe, 6 months or less to live, then they could enter into a joint guardianship with someone. Now, a joint guardianship with AB 495, it was expanded to include other situations like deportation or incarceration. And I believe, Sharon, jump in if I have this incorrect, but the joint guardianship would begin once an event that was contemplated happened. So, for example, if the parent was deported, that's when the guardian's powers would start, right, Sharon? Oh, I saw you come off mute, but I can't hear you. So we'll put a pin on that. I see from Paula, can you address the importance of necessity in guardianship cases more important than best interest? So, where a guardianship is necessary and convenient. So, in my experience, I have seen that the court grants guardianships. They consider the necessary and convenient, but they find that it's necessary that the child's best interest be considered. So it gets kind of circular, at least in my practice. And so even though for example, in a case where a child has been living with a guardian for an extended period of time, the person maybe has been caring for the child for more than half the child's life. The court would find that it is necessary that the guardianship be granted to serve the child's best interests. Um, yeah, it's necessary or convenient, yes, and it doesn't have to be both necessarily, but I find that judges kind of if it's in the child's best interest, it's necessary, and if the child has been living there, it's also convenient. Um, any strategies? Let me go back up to David. So for the CAA, the phrasing on the slide confused me. Are only non-relatives unable to use the CAA for the activities on the slide, or does that apply to relatives and non-relatives? Um, so non-relatives can use the CAA and so can relatives. Relatives have slightly stronger powers with a CAA that a non-relative would then have to get additional authorizations, for example, to consent to special education for the child. And then Carrie, any strategies when a parent has remedied all of the issues that led to the guardianship, but the child doesn't want contact with the parent? Oh, that is so tough. Again, in cases like that, one strategy that we found is asking for conjoint therapy, asking the court order therapy, and hopefully there has still been some contact with the parent. And if there aren't visit orders in place, maybe starting from asking the court to order therapy for parent and child would be a good place to start. If you can show that the reason the child doesn't want contacted with the parent is because of the guardian's interference and not just because of feelings that the parent has, but actual canceled visits. And depending on the age of the child, that would also be key. I would say if the child is over 12 years old, the court is going to really, take the child's feelings quite seriously. But if they're younger, they might be more receptive to the argument that the child was manipulated by a guardian. Um, and yes, I see Alexandra that you notice you wrote in the California Rule of Court, which outlines all the steps a petitioner must follow in their due diligence search. Yes, I wish that in the practice that we have seen at least that courts were really holding petitioners to this standard, but in our experience they do not, and it can sometimes just be a statement that mom is in a homeless shelter and I haven't heard from her in several weeks, and that can be all that the court finds is necessary to waive notice. So it can be, I think showing that that the petitioner did have all of the ways to contact the parent and did not can be should be presented to the court by parent if that evidence is available. How do we best mitigate the cost of supervised monitoring by a professional? Um, I think that if you can get um, the cost of supervised monitoring, I think if parent has access to counsel, if we can get involved sooner, then getting the really stressing to the court that the parent does not have ability to pay and finding an alternative monitor. So there's Sharon. Let me unmute Sharon. I don't know if I can unmute you, Sharon. Okay, and then I think that covers all of our questions. And mitigating the cost of a supervised monitoring, I think that that's where I'll just circle back because I want to make sure I answered that. But it would be making sure that there's an alternate person who that hopefully everyone can agree on that can supervise the visits. So thank you all
Oh,
so
sorry,
much
there's
for your
one more question.
participation.
There's
Oh,
one more
okay.
question in the Q&A. Should the parent trying to terminate guardianship let the court know that the guardian submitted a lot of false information in an effort to obtain the children? Yes. So this is what testimony is for, to really lay out that whatever the guardian said wasn't true. And if you get all the way to the trial stage, you can bring witnesses who can also testify to that. But yes, absolutely, the parent can and should be making it clear to the court that the guardian has misspoken.
Yeah.
Potential guardian.
It can be difficult to actually to impeach someone based on what they put in the petition, but if you in your initial objection, for example, or if you do end up filing the ex parte request to terminate the temporary, you can put the court on notice of the guardian's bad faith actions that they took to in that they misled the court, for example, especially if you have that evidence to show. So thanks so much, Alero. Thank you everyone for your questions. Um, I am really glad that we had such great participation. I hope you all have a wonderful rest of your day, and we'll be sending out the manual and the slides to everyone who came today. Thank you all so much.